Gentlemen, if I could have your attention and welcome you to this seminar on uses and abuses of mediation. To congratulate you also for being here so early in the morning and express the hope that your investment in the time will be useful. We'll certainly be making every effort to make it valuable and relaxing. We want to make it a conversation. This is not a lecture, it's not even a tutorial, it is a conversation. We have prepared ourselves, of course, for it, and we have all had experience in mediation. We want to share that experience with you, but we can all learn from mutual exchange of ideas and experience. And we hope, therefore, that you will join in the spirit of that, because it will produce better results rather than just have a few talking heads here lecturing you. As you see, I'm accompanied by some distinguished colleagues of mine. Two of them are on Green's list, and Judy Heeps. The third is a solicitor with Marshall and Dent of many years' experience and practice, not only in the law in general, but in mediation. I'll introduce them in a bit more detail in a minute, but I didn't want them just sort of sitting here without any explanation as to who they are. We'll come back to them in a moment. Now, as you know, this is the third in this series of discussions on mediation. I don't know whether this is entirely accurate, but I'll put it to you for your consideration. The previous two were really preparation for today. The previous ones were, in one sense, I suppose, an introduction to it. I don't know, I know some of you were actually here for the previous one. For the previous two, rather, the first being an overview, which was given the subheading Horses for Courses, and that dealt with all of the various forms of dispute resolution, from litigation through arbitration, expert determination, mediation, so on and so forth. The second session was concerned with mediating for the best result. What you could do to enhance the prospects of having a good mediation by having the client prepared and by preparing the mediator, the exchange of position papers, the techniques of mediation advocacy if you're a lawyer representing people at a mediation, and the all-important documenting the settlement if there is a settlement reached after the mediation. Now, those subjects were covered in the first two sessions, and as I say, that's very good preparation for the serious business of the uses and abuses of mediation, which we're going to handle today. I mention that in a bit of detail because it's not as if the subjects that I've just listed from the two previous seminars are out of bounds. I think our conversation will almost inevitably go into those subjects from time to time, and I hope you'll feel free to raise any question you like or contribute in any way you like to the discussion on any of those subjects. But today we're going to get into the really serious parts of mediation under the heading Uses and Abuses. I'm going to start off by us having a quick look at the uses, because generally speaking, I think we all feel that mediation is valuable and worth a try. It's not a perfect system, but it does have merits, and we should recognize that. We're then going to go into the abuses, which regrettably there are in mediation when, for example, a party fails to negotiate in good faith. What can you do about it, if anything? There's the issue of confidentiality, because sometimes after the mediation there may be an attempt to use material that was part of the mediation in a more contentious way if the dispute was not settled. So we'll be looking at the limits of confidentiality. We'll be looking at how the mediator conducts him or herself, and if, as you know, one of the issues in arbitration in particular is actually described quite bluntly as misconduct by the arbitrator. And we've given that a heading here too, misconduct of the mediator. Under that broad heading, you'll have an opportunity of discussing with us this vexed question that comes up with so many mediations. That is, what's the role of the mediator? Should the mediator be sitting there simply hoping that eventually the case will be settled if the offers are high enough or low enough, as the case may be? Or should a mediator do more? Should a mediator be intervening and suggesting solutions to the parties? Should a mediator even go further than that? Some mediators, and it's a matter we can talk about later, some mediators actually do this. They actually say, you're going to lose this case, or, which is worse, you're going to win this case. And that is a view which is not universally held by a lot of people who work in this field. And I suppose it's fair to say the traditional view is that the role of the mediator is to try to bring out the best from the warring parties and trying to get into their minds that the solution is theirs, it's in their hands, and you have to try to get those solutions emerging from the parties and discussing the issues with them. So that's one subject that we'll be talking about. And then there'll be the question of sanctions. What happens if there hasn't been a proper mediation? If there is a good mediation, the case is probably settled, but what if it's not? And what if there's some shortcoming on the part of parties or the mediator? Are there any sanctions? One thing that people overlook is that in a number of areas there is actually legislation on this subject now, and we'll touch on that, I should think, as we go by. But there we are. That's basically what we're looking at and where we're going, and I think you'll agree with me that they really are the contentious issues of mediation that arise, and which, if you debate and argue about them, I think you can learn from that, and from that experience take part in better mediations than you may have had in the past. So, I want to emphasize again, just before we start, that this is your, I'm going to slip back into using the word seminar as a neutral word, but this is your gathering, your conversation, your party. We would like you to contribute, and you will get more from it if you do, and if you don't, I'll ask you questions anyway, in the best traditions of the Harvard University law course, where professors don't exactly embarrass students, but they do their best to make sure that all students take part, and I'll be doing my best to make sure that you all take part. And in any event, if you have questions at any time, please jump in. We won't have a formal question time. I'll try to encourage you to speak as the spirit moves you as we go along. Now, I want to introduce the team in a bit more detail. Magee, who is sitting on my right here, was admitted to practice in 1984 and has worked at Phillips Fox and has been at the bar for a number of years, practices largely in personal injuries, common law litigation. Been doing that for 25 years, you must have done a lot of mediations during that time, as I understand it. And we're going to draw on your experience, Anya, in those cases. Judy Heeps is with Marshalls and Dent and joined the firm in 1986. It's very stable, long-term friend of Marshalls and Dent, and has had a wide experience, still currently practices in employment, trade practices, insolvency and intellectual property. And she has had a long experience in mediation particularly from the side of the solicitor acting for the lay client and preparing them for mediation. And I'm going to draw on her experience too in that regard. And then we have representing the younger sector, Stephen Jurica, who's a member of our list. He's actually very young and he knows all about Twitter and Facebook and Lady Gaga. And we're going to draw on him when we get stuck in a corner. When I'm feeling older than usual, I'm going to seek help from Stephen, and he will, I know from our preliminary talks, come to my aid. Now, I thought because our subject is uses and abuses of mediation, we may as well start off with uses. It's not all bad news, the problems that we're going to talk about today. Some of it is good. So there are uses of mediation, and I thought I therefore might put Judy, because of her long experience in working with clients, on the spot to start off. By asking her this. Judy, do clients generally, I know there are qualifications to any proposition, but do clients generally find mediation a worthwhile thing in the course of the litigation involving their dispute, or do they all think it's all a waste of time and just one more expense? But do they find it useful, and does it help you in your work as a solicitor?
Yes, certainly over the years I found that clients embrace the concept of, of mediation, because in front of them is the trial, which involves significant costs, and at that stage you forewarn them of the incredible amount of costs that are going to be involved in a trial. So they do tend to be enthusiastic about the mediation process. I think also by that stage they're also worn down with the costs that they've already incurred to date, insofar as having gone through the interlocutory process of discovery and further pleadings, and so the magnitude of costs is already hitting them at that stage. So they do tend to, as I said, embrace the mediation. As both a client and as a solicitor, I find it a very useful and beneficial process in that it makes you focus on the case at an earlier point in time than just prior to preparation for trial, which pre-mediation often was the case that you sort of only get to grips with what your real weaknesses and strengths were in terms of evidentiary strengths just prior to trial when you were doing that massive preparation. So I think the process has that benefit because it gets you to focus on, well, where are your pitfalls, and therefore the client therefore gets to identify with the weaknesses and strengths of their particular case at an earlier point in time.
Are clients sometimes or generally or always afraid of giving away too much of their case when the mediation is coming up?
I think it varies between client and client. Obviously those that aren't professional people, sort of if you know, the young mum and dad or the mum and dad who aren't familiar with the process will be more concerned about what they should say, or rather what they shouldn't say, and need a lot more direction from the practitioner in terms of, you know, being allowed to talk or not being allowed to talk. However, a lot of people do like to talk and do feel that that's part of the process, and so I don't necessarily as a practitioner try to stifle them, although obviously we do give them guidance that counsel and solicitor talks first, and if they want to add anything that they feel has been missed or that they want to say, then that's the opportunity for them to say it.
Right. How do you, just briefly, how do you prepare them for a mediation?
Well, again, it varies, but usually I do explain to them the process, unless of course they've been through it before. I explain, you know, where we're going to be, I think what sort of room, you know, we're going to be in a room together, each party's going to have their say through their legal representatives, and then we'll break into separate rooms. So I do actually go through the process and give them a sort of grassroots of what it's all about.
Yeah. Well, that's very valuable, and let me just get a different perspective. Stephen, although I gave you a very brief introduction, you've had experience in property and commercial and related commercial disputes, some of which have gone to mediation, I know. Has your experience been similar to what has just been described in general words by Judy?
Definitely, Neil. Most of the parties do embrace, as Judy mentioned, mediation, and it's the most popular form of ADR. That 80–90% of cases do go through mediation. Early neutral evaluation is starting to become a bit more popular now. We're following the states, but essentially people and the parties themselves really want to get things off their chest, and they want to have that day in court. So the next best thing is mediation without getting all the costs involved. So they really feel it beneficial getting things off their chest, narrowing the issues in dispute, and then generating some options and talking about interests in trying to resolve the dispute. So I find it very helpful on all the parties that I've dealt with, and most of the time do settle the case. I think it's only about a small percentage actually go on to trial because it's very expensive.
Now you do mediations as a mediator as well as a barrister appearing for clients. Do you take a different, do you see your role as markedly different between those two positions?
Definitely. As a mediator, obviously I'm not there to advise, I'm not there to draft settlement terms, which I don't go anywhere near, as I don't want to get sued.
It's a problem we have to talk about later, I think.
True.
Who draws the mediation settlement, if there is one?
And then when you're acting on behalf of the party, you're more, I suppose, bullish in your approach in the sense of trying to get what's best for your client. And at the end of the day, it's their case. They're the one that's going to decide what to do, whether to settle, whether to compromise, or whether to go on to court. So you do your best in advising them, letting them know the legal issues, making sure they understand them, making sure they're aware of consequences, any other legal actions which may arise, all those sorts of things. So you're really there to be the advisor compared to being a facilitator, making sure that the parties are talking and really showing them that, the BATNA and WATNA, I suppose, as far as, the best alternative to a negotiated agreement when you're a mediator and you're having those private sessions and you're really trying to bring them down to earth.
Okay.
The other thing too, Stephen, is when you are acting as a mediator, one of the things I think is important is that the mediator, if there's some speed humps along the way in the negotiations, to try and assist the parties over those speed humps. And therefore you can't be partial, you've got to be totally and utterly impartial, because you need to try and help facilitate the final result. Now the final result might not be an ultimate settlement, which often happens. But another aspect of mediation is you can still have a good mediation without a settlement when at the end of the day the real issues in dispute are crystallised. So all of the non-contentious issues have been identified and put to one side, and the real contention, the matters are there on the table, and people go away from the mediation perhaps without a resolution, but knowing at least out of the 5 matters that we thought we were going to be arguing about, we're actually only arguing about 3. And that of itself can be a great assistance.
Your practice is largely in personal injuries, I know. Do you find, just in general terms, that your experience is similar to Judy's, that generally clients find the mediation process a useful one for them to have been through?
I think in terms of individual plaintiffs, as distinct from professional litigants who are usually there on the other side, that's something that people have to have a great understanding of, because there is that perhaps David and Goliath feeling that the plaintiffs might have, that they're coming up against a professional litigant. And that's a reason why in most personal injury cases the individual plaintiff is not kept in the sessions. They're usually kept separate. But one of the things I think I found helpful, and I'd be interested to see if other personal injury people here have had the same experience, it's often helpful for the plaintiff to see a representative from the insurer, to see that there is someone, there's a human face to it.
And is there?
Well, they should be. They should be. And in circumstances, in the sort of work I do, where we predominant TAC or work cover, for example, the TAC have a group of people that that's what they do. They attend the mediations. They're there. They're properly authorised with levels of authority to settle and things like that. And they are, on the whole, they perform their activities very professionally and personally. And sometimes that's very helpful for a plaintiff to say, well, even though I'm not getting quite what I want, the person understood and recognised that I have suffered
that I have had pain, that I have had consequences. And I think that in itself can be very helpful for a plaintiff, that there is someone acknowledging
yes.
Their situation.
Yes, that's right. One of the uses of mediation, which is a good use, I think, is bringing the parties together, no matter what the result might be. And although I think we'll all today be talking about cases of our own, I had a particularly difficult, some weeks ago, construction mediation. Difficult in many respects, partly because there were so many parties and because they were so many $1 million apart. But the case was not settled, I regret to say, at the mediation, but it was still a valuable mediation. And I heard indirectly after, some weeks after that, it was the first time in 5 years that the parties had come together. And as a result of that, the senior people from each side in the two principal parties actually went away together to have further talks about it after the mediation was concluded. I haven't heard the result, but certainly it was a very good softening up process. Now, would anyone like to add anything just before we go on to the abuses and the problems in mediation? Generally, whether you, by using it, have found it useful and valuable? Is it something the courts are right in directing people into mediation as soon as possible? Is it something where governments and legislatures are correct in making it virtually compulsory in most cases? And do you have any contribution you'd like to make on that? Yes?
Yeah, I'll just
yeah.
Sorry.
Yeah, we've got the roving microphone which Matthew will pass around. Turn it on.
Yeah. Just two observations. One is that, and the discussion's already drawn this out this morning, is that mediation gives flexibility. So you can ask a question like, should we let the clients talk to each other directly, which is something that court procedures don't give, and that's a real plus. And the other thing, speaking as a commercial litigation solicitor, is that it's a great opportunity to spend a period of time with your client, and actually, in a sense, it's almost marketing that you're getting paid for, because yeah, there's a lot of downtime in a mediation, and when the mediator particularly is in the other side's room, and you're in your breakout room, and your client and you are looking at each other across the table, you do start to talk, and you just shoot the breeze. And sometimes at the end of that, I find that the client actually and you have struck a chord, in a personal sense.
This is with your own client.
With your own client, and because it could be that it's a client that yes, you do work for from time to time, but you've never had the opportunity or taken the opportunity to sit down and just talk about the football or the family or whatever with them. So that's also another positive, that you don't get that chance during a court trial generally.
I have one, probably in many ways the best mediation I've ever had and the worst mediation I've ever had between some warring parties in Sydney. It started about 5 years ago and it's still going. I find it very hard to believe. I've sort of transmogrified myself into being an arbitrator now. Every time a problem arises, they get onto me and I try and arbitrate it. But they hate each other so much that they won't communicate with each other and they keep turning to me for solving their problems. It sometimes gets to an embarrassing point where you feel, I really should be out of this, but it seems to work for some reason. In any event, anyone else like to just say anything about how useful mediation is before we go on and look at some of these problems that I articulated? Yes, lady.
Sorry, I'm a plaintiff lawyer in personal injuries work, and I suppose I have 2 or 3 thoughts about mediation. Most clients, when we first meet them and consider whether they're going to make a claim, are petrified about the idea of court and are excited to hear that it's compulsory to have a mediation. And so I think that's certainly one thing we shouldn't be frightened about them occurring. I also think that they're always useful because, well, perhaps not always useful, there's 1 or 2 bad ones over time, but they're largely useful because, of course, they do identify the issues. And even those clients who've turned from being frightened of going to court and who want to go to court usually have a sleepless night the night before the mediation. And I think that's sort of sobering for them and for us not to be too bullish and to appreciate that there are considerable risks in, not being pig-headed about a case. So I think that's a useful part.
Yes.
And then I think someone it might have been you, Neil, who mentioned that it was good for people to get together, the solicitors or barristers to be together at the mediation, and it reminds me in a very small way in personal injury work that I think it's a bit of a pity that the courts are doing so much on the papers now instead of having directions hearings where you go to court, you bump into the solicitor on the other side and you actually have the conversation. Why is this thing still hanging around? What are the issues in dispute? I know you should be able to pick up the phone and have that, but being in court together, sitting around waiting to...
Yes. Conducive to that.
Yes, it is.
Yes,
it is,
yes.
And I think that that's probably. I mean, sorry, that's not about mediation, but I think it just shows you that by getting together, you can usually work out what the issues are, or work out something that's important for the other to know about the case. It is big, it is small, it's whatever.
Yes, thank you. That's very good. I'm pleased to see Mr. Robert Ewing is volunteering because he's had a lot of experience himself in this field. So, Robert, could you make a contribution?
I'd just like to add this.
Microphone coming up.
I'd just like to add this as a use of mediation, that you have the capacity in negotiations to reach a compromise which may include issues such as time payment arrangements for one of the parties. In other words, you can negotiate a settlement and a framework for the settlement which you could never obtain from a judge because it's not within the judge's interest.
Or interest.
Yeah.
Yeah. Okay, that's good idea. All right, let's move on to some of these problems. And one of the problems, of course, which you might say is at the root of the unfortunate side of mediation is where one party refuses to negotiate, certainly in good faith, either from the beginning or in the course of the negotiations at the mediation. And I'm going to ask our panel members to contribute on that. To give you a bad example, I hope it's at the extreme and a rare event. I think it probably is rare. I was talking to a member of this bar. This was really now over a year ago, and asking him about his involvement in mediation. And he said to me that he'd been briefed in a series of cases. I think there must have been a common party involved in them where his instructions were to go to the mediation and make the opening statement and then walk out, presumably to show how tough they were and how irresolute they were. That's not the right thing to do, but I'm just wondering whether the panel members, in a general sense, have come across this problem of the difficulty of getting the other side up to the mark to take part in a mediation, the difficulty of getting them to do it properly and enter into the spirit of it and to contribute and take an active part in it and be properly represented, and all of the other things that we would like to see. Judy, do you come across this in your practice?
Look, it's more on a rarity, I would say. Times when it has happened, it's usually been instances where the other side has turned up with perhaps legal representation but no representative from the client, or they've sent along the junior officer who hasn't got authority to discuss settlement or even know about the issues.
And makes a great show of it.
Makes a great show of it. There are other instances where I've had experience where the opposing party has just taken exactly that, the stonewalling. This is our position. We're not here to negotiate any further. I found that you're very limited really in your recourse in those instances, apart from sort of throwing down the gauntlet and saying, oh, this is bad, not good faith, we want costs. Obviously this mediation can't proceed, it's been a waste of time. You should have forewarned us, for instance, that your client wasn't going to be here, or you were sending the junior along. And so, in reality, the only way I've sort of found that you can agitate that is to seek costs. It doesn't necessarily solve the problem in that you don't end up with giving your client that fruitful experience of being able to go through a mediation process. And often it's just resulted in, oh, we'll get Mr. Managing Director on the phone, he can give some instructions, so to avoid an audit of costs. So I do find that I've never actually brought a proceeding or a complaint in relation to a failure to mediate in good faith. And again, you'd probably consider the cost consequences and tactical benefits of doing all of that. Litigation is expensive enough without going off on other tangents. You've often got to go off on many tangents anyway, agitating about adequacy of discovery, to then be agitating about failure to mediate in good faith. So on a practical level, I don't think it's something that you necessarily would pursue as a solicitor anyway.
To use the failure to mediate properly as a ground for having an order for costs made, or reducing the other side's costs?
Well, you may threaten that, but at the end of the day, it's a rarity to either get, for instance, say at the magistrate's court, often you'll ask the registrar, well, that's the circumstances, they haven't shown up, or they've sent to the junior, we want an order for costs. Now, as I said, it's often circumvented by getting Mr. Managing Director on the phone, but it doesn't necessarily result in a costs order or them being penalised in any way.
Yes. Right. You're right in drawing attention to that cost factor, and I mentioned in my introductory remarks that there is legislation now on a number of these issues. There is actually legislation on that in several respects. One is that the power to make cost orders is always in the discretion of a court, and sometimes that is expressed in legislation, sometimes it's just assumed. For instance, I was noting last night that there's an express provision in the Federal Court Act to that effect. Note also that in the Federal Court Act and in the Victorian Civil Procedure Act, there is a power to order costs against a party's lawyers if they do not act properly in the mediation and take a constructive and sensible approach to both taking part in the mediation and what they do at the mediation. So it's not exactly an unlimited go. You are subject to the legislative requirements, and it's wise to have that at the back of your mind. But how have you two felt from your experience about this issue, where we find one party is not willing to take part in a mediation, or takes part in it but in a very nominal sense without entering into the spirit of it and not being constructive, not sending someone with authority along to the mediation, not contributing anything, perhaps in the extreme case that I mentioned, actually walking out after making some heroic declaration which they think is a sign of toughness. How have you found, Stephen, have you had that experience?
I haven't had that experience, but a colleague at the bar was doing a mediation as a mediator, and one of the parties in some colourful language said, F off, I'm not doing this, it's a waste of time, I'm walking out. And that party walked out after about 10 minutes. Now, apparently I asked the next question, what happened? And apparently the other side made an application as to costs, attached an affidavit saying the other party walked out after 10 minutes. That is not negotiating in good faith. And they got a cost order for about $10,000. So I suppose that's one example. If one party leaves like that, then that's bad faith negotiation. And also when they come to mediations without authority to settle, they should always have someone there who can have authority to settle, or can quickly get someone on the phone or someone to come along and sign whatever they need to sign. So they're the two examples I have. And Section 29 of the Civil Procedure Act does point towards the fact that the court can make certain orders, and that relates to costs, ordering parties to take certain steps, and they can make any other order effectively. So it's quite a broad discretion that the courts now have with the Civil Procedure Act, and it's really trying to get the parties to negotiate.
Those of you who practice in the federal jurisdiction would be familiar, or if you're not familiar yet, you're about to be familiar, with the Civil Dispute Resolution Act, which has provisions in it which are analogous to the Victorian Civil Procedure Act, and impose quite detailed obligations on parties and their lawyers to take genuine steps to try to resolve the dispute by mediation or some other form of alternative dispute resolution. It's done by means of what are called genuine steps. You have to take genuine steps, and you have to file a genuine steps statement to show what it's like Arthur Murray's dancing school, but I think I get the idea of what they want. To show what genuine steps you have taken in the course of this stately minuet we call litigation. So that's there, and the consequences are severe, of course, in terms of costs and in the court's impression of the merits of a case where the parties and their lawyers don't conduct themselves properly. So I think it's wise always to keep that ultimate sanction. You can always drop hints about it to the other side, of course, of what might be in store for them, especially if Stephen's friend is acting against them. They're running the risk of having an order made against them for cost, at least the cost of the mediation, which I presume that cost sort of was. Anya, have you had any experience in that field? Yeah. Yeah.
One interesting point from what you just said, Neil, is in the federal court you're under a docket system, aren't you? So
yes.
you stay with the same judge.
And the judge will remember. Yes.
That's another piece of information to go into the mix, that it doesn't go to a different judge at a later stage. That judge will be aware of history. In terms of problems about people turning up to mediations without any intention of settling, I can only really recall one specific instance where a plaintiff had put their opening statement. There were a number of defendants, and one of the representatives, who was a senior partner in the law firm representing one defendant, sat there and said, "I have nothing to say," and sat there for the rest of the mediation, body language, clothes, just like that. It wasn't very helpful mediation.
No.
But I think one of the major problems from the area in which I work is where there's someone, and we've all touched on it, lack of authority to settle. People are sent
in personal injuries claims. They can only go to $100,000,
and the claim is always
$2 million
more or whatever. Now there are some where it might be that the person who is sent has authority to a certain level, that the claim looked as if it was within that authority, and something may have happened to take it out. That is, I think, a different scenario from when someone is sent on a claim that has, I'm making these figures up, $500,000 value, and the person who's sent along is only authorised to go to $100,000. To me, that's not good faith. If a claim properly assesses within a range, the person who goes to the mediation should be authorised within that range, not at a lower range to try and force a cheaper settlement.
Anya, have you complained when that has occurred? Have you actually said
often,
this is...
often what happens is that the phone call gets made and we get sent off for coffee, and then someone with authority is able to do something. But it can be very, very frustrating. But the other issue I think you have to look at from, say, the defendant's perspective is if there is late notice of particular issues, they might not have been aware of those issues and have sent someone that they thought had appropriate authority. So it's going back to the dance routine, it is a fine line, and if the parties cooperate as they're supposed to now under the Civil Procedure Act, that should hopefully be minimised somewhat. But I gave the example, I was chatting to Mandy Bear just before when we were having breakfast, of a mediation I went to recently where it was an injured party suing 3 defendants, and I was acting for a statutory authority seeking recovery of payments that had been made. So there were 2 sets of proceedings. I think there were maybe 5 or 6 sets of parties there. One of the parties, one of the defendants, sent along someone who had authority to less than half of what the recovery action was worth, let alone the injured party's own claim. And it was clear that that person could never have had proper authority to negotiate with any of us. And the mediator then actually made them go and find someone with proper authority, and eventually part of the claim resolved, and my part didn't get resolved sometime later. But that creates great difficulties for people.
Were they admonished in any shape or form? I mean,
they were admonished privately.
Privately. I mean, I again repeat that there's not a lot that you end up doing in terms of bringing it back before the court to sort of have that person, formally admonished or at least penalised by a cost order. On a practical level, it usually actually just moves along. It may tactically give you some sort of up by saying we're not treating this with any respect, we're not acting in good faith, but at the end of the day, there's not a lot you can do about it, or do about it.
Lady.
Well, sorry, I think Anya covered my point, but
covered it, yes.
But just to that extent, that it's not much point having someone there without the authority, or when you turn up and the Sydney insurer is only available to be called from time to time. I mean, the whole idea of the presentation from either side of the view is to have someone hear the arguments being teased out. And so I don't think the summary by the solicitor or whoever to someone in Sydney who's concentrating on something else is really a substitute for being there.
Good.
There can be exceptions. I've got an example that's coming up where it's a multi-party dispute. A number of the defendants are interstate. It was an accident that happened in Queensland and the Northern Territory. My client, who was coming to the mediation in a week's time, has broken his leg, has got a DVT and has been told he cannot fly and should not fly. We have told all the parties about that, and they have agreed that he can be available by telephone. Because I didn't want to turn up to the mediation and say, oh, I don't have anyone here, they're on the phone interstate, and people raise an objection at that stage. People know about it now. I'm sure he'll be available by phone, and I have to accept that my instructors have arranged that, and we will negotiate, see how we go. But the parties they all know about it, and so there's no drama. It's when you don't know about it that it causes a problem.
Comment on the side?
Hi, Luke Stanistreet. Just quickly, my background's a solicitor, then Judge Associate at the Supreme Court, and I'm now at the bar. So I've had experience of mediation from a few different angles already.
Good.
Firstly, when the Supreme Court standard mediation order says that the parties attending must basically have authority and the lawyers attending must have the authority to advise those people who are going to settle it, I find it odd that the mediators aren't putting in their mediation agreements who should be attending, and frankly, if they're not, I think the parties or someone should say to the mediator, can you drive this to make sure that people are there? I don't doubt it happens, but I do find it pretty odd, and I think that it's really should fall on the mediator to have a bit of control where they're setting up what they want the parties to do. The second point is...
Did you say put it in the mediation agreement?
Well, I don't see why not. I've seen it in mediation agreements before.
Yeah, right.
I have seen it in them before.
Yeah.
And it stops the parties wriggling out of it. And I think that's probably the sign of a good mediator who's thought about some of these things.
Not only do I agree with that, but it's an even more basic proposition that there should be a mediation agreement. There doesn't seem to be a universal knowledge or understanding that it's very important that before you have a mediation there should be an agreement entered into. I don't know whether you are aware of that, but there are provisions in what you might call the normal mediation agreement which are there for your value, for your benefit and that of the client, particularly on confidentiality and on what the mediator should do. And even although a mediation is, say, in the case that you mentioned, under the protection of the court, and the mediator is protected by virtue of that fact, there are many mediations where there is no litigation on foot, so it's very doubly important to have a mediation agreement there. And secondly, even where it is directed by the court to take place, it's useful to have the mediation agreement. If you have trouble, by the way, in knowing, do you all know what a mediation agreement looks like, and do you have access to useful ones? There are a few people nodding. No? I have one which you can certainly have if you like, which originated with Sir Lawrence Street, one of the doyens of mediation in Sydney, and with a few, I hope, improvements of my own and a couple of other people as it's gone through the mincing machine over the years, but you can certainly use that if you like. I can give that to you. If you give me your business card, I'll send one to you even by email. That's very useful, but I've cut you off halfway through. I'm sorry, you were going on
the
with
second
some other
point
points.
was on the authority to settle, and I was involved in a mediation that ran for about 13 hours. It was about a $2 million claim, and I think in the end the deal was done for 400. And there was an issue with the CEO who was there needing to, he had authority up to, let's say it was 400. Yeah. And there would have needed to have been a teleconference board meeting, all the rest of it. And the other side was sort of saying, oh, you know, this is outrageous, that you haven't come with enough authority to settle. What kind of person comes, what sort of CEO comes with that sort of arrangement? And the senior associate on my side smiled and said a prudent one. And I think there's a prudent one. There's no doubt that you would need to be in good faith and to be at a certain amount. But if your own legal advice is that at a certain figure, I don't actually see a problem, and there might be constraints of having to convene board meetings over the phone and things. I think as long as it's on the basis of sound advice that this figure's in the ballpark, I think that's okay. If people deliberately only have low authority, that's a different matter, but strategically it did work in our favour in that particular instance, so yes. Horses for courses.
Yes, horses for courses, indeed. Now, any other?
I was just suggesting, back to the mediation agreement, I find it a useful practice when it's sent to me, that I send it to the client straight away and say, read through it so that you know and appreciate and understand what's going to happen. Because often on some occasions, they're presented at the mediation and you don't have time to fully acquaint your client with what's involved. So I just found that's a useful practice.
Yes. And I don't know whether this is the appropriate time to raise it or not, but I will now. What you've just said is particularly appropriate, I think, in a case where you might fall foul of the problem in the late Mr. Richard Pratt's case, where, as you know, there was a problem about revealing in subsequent litigation what had been said in a previous mediation. To some extent, that problem can be avoided or alleviated by putting provisions in the mediation agreement to make it plain as to exactly what you are doing and what is covered by confidentiality in the course of the mediation.